joining us today for our webinar on Maine's Paid Family Leave Act. We know this has been on everybody's mind, so we're really hopeful that today we can help you feel that you and your organization are better prepared and better informed for this. I'm Leora Kirk. I'm from KMA HR. I have worked for HR for the last 15 years, and there's never a lack of excitement, as we all know. With me today is Amy Parsons of Ogletree Dickens. Amy is a management side employment lawyer based in Portland. She partners with employers to advise on all aspects of employment relationships in Maine and through the US and globally. She has been practicing for over 20 years and focused solely on employment law for the last 14 years. Leave of absence is one of her specialties. Also with me today is Shelley Pauls from Acadia Benefit. Shelley's expertise is in strategy and design of employee benefit plans, as well as ongoing evaluations, negotiation, and administration of those plans. She brings over 30 years of experience in the insurance and financial service industry. I want to extend a big thank you for our partners at Ogletree and Acadia for sharing their expertise with us today. To get started, I just want to share this disclaimer that this presentation is provided for you for informational purposes. It is not, should not be intended or construed as legal advice. If you need specific advice, please consult your attorneys in connection with any fact-specific situation or any financial obligation that that you or your company or your organization might have. And then some housekeeping notes for today's presentation. So, as you know, this is a really active and developing topic. MDOL just wrapped up the comment period. They're set to a second comment period. They set to release revised rules after the closing of this period. Their deadline is by the end of the year. We're really hopeful that it will happen a lot sooner than that. We have done our very best to address any questions that were sent to us at the registration. We know we typically promise a Q&A section. We have close to 500 people who were registered for this webinar, so we didn't think that that would be very productive or that would be able to answer questions. Saying that, the chat feature is open. So if you have specific chat messages you want to send, you can send those. Those will go to us, the panelists, and we can see if I am getting a lot of chats that are asking the same thing or saying the same things, then I will try to bring those up to Shelley and Amy. Lastly, this webinar is being recorded, which you may have seen when you logged in. It will be posted to the KMA website in the next day or two. However, we don't make slides available, so please, if you want to make notes, I also realize it's lunchtime, so feel free to relax and listen and try to take in as much as you can. Like I said, it's a lot. We're going to cover today an overview of the rules as we know them, requesting and taking leave, planning for 2025 and planning for 2026. As some of you might know, this is a phased, so there's going to be different obligations in different phases as we wrap up as we sort of ramp up for this. So as we talk about overview of the legislation, in July of 23, our governor signed a budget that included the creation of the Paid Family and Medical Leave Program. This law does apply to virtually all employers with employees working in the state of Maine, and Amy will help us define that as we go on. Beginning in May 2026, eligible workers will have available to them up to a combined 12 weeks of paid leave for family, medical, safety reasons, and we'll cover those eligible reasons as well. The first thing that you will see, and which is starting we're 3 months away, January 1st, is the contributions to the program. We are front funding this benefit. So contribution to the programs will begin January 1st. Premiums are set at 1% of wages, and it's capped at the Social Security wage base. So for employers with 15 or more covered employees, they have to remit 100% of the premium, so that's 1%, but they may deduct up to 50% of that from employees' wages. For those employees who are 15 or less employees, they have to remit 50% of the premium, but they can deduct that entire amount from employees' wages. The benefits will be capped at 100% at the state weekly wage, and you have that there in front of you for 2024. And employers may request to substitute an approved private plan, which is substantially equivalent. And Shelley will help us decipher what that looks like. Employers can apply for private plan substitutions after April 1st. So there's a bit of a difference in the dates there to keep in mind.
Great. Thanks, Leora. I'm going to just jump in here to point out there is an effective date exception. And this is applies to public employers and public employers only. And this is important because we do have some public employers who are registered for the webinar. And this applies to employees that are subject to a collective bargaining agreement that was in effect as of October 25th, 2023. And for those employees, contributions to the public plan, which are scheduled to begin January 1, 2025, but for these collective bargaining agreement employees, those premiums will not need to be paid until that particular collective bargaining agreement expires. So effectively, if it expired prior to January 1, 2025, then those employees will have premiums paid on their behalf beginning January 1, 2025, along with every other employer. But let's say that contract expires June 30th, 2025. Then premium payments to the public plan will not be due until July of that year. And I'm going to pass it back to Leora.
Thank you. So I know a few people asked this question when you submitted your questions. Is that right? This question of how do we actually count employees for this? And so, employers employing at least 15 employees, and this is based on your federal ID number, on an established payroll at least 20 calendar work weeks during the 12-month period ending on September 30th each year will be established as employing 15 or more employees for that calendar year. All employees count towards this. So so this isn't full-time employees. This is all employees in your organization. So total number of persons in an establishment on your payroll can be full-time, can be part-time, can be per diem. You count them all towards that 15 number. We are gonna, so again, this applies to the deduction, not to benefit eligibility, and we'll talk about benefit eligibility. Amy will get into that. I'm gonna pass this over to Amy to talk us through how to request and take leave.
Thank you, Leora and Shelley. And just circling back just to the counting employees for FMLA purposes, again, that's going to recalculate every year. We're looking at September 30th. That was yesterday. And that will be your number in looking forward to the next year. So employees will know what their deduction and contribution amount is for 2025 based on their 20 weeks of 2024. So talking about requesting and taking leave. I'm going to jump right into which employees are eligible, but before I launch into that, I did want to call your attention to the fact that we understand the Maine Department of Labor issued a press release yesterday that may or may not have landed into your inboxes. And the Maine Department of Labor is going to be sponsoring some, I don't know if they're interactive yet. We just know that they are some webinars. There are going to be 2 webinars for employees to participate in and 2 webinars for employers to participate in. These are going to take place during the month of October. I assume that if you check the MDOL's website on the Maine Paid Family Medical Leave section, you can find that press release. Otherwise, it may land into your inbox soon, and you can register as an employer for one of the informative sessions that the Department of Labor is supposed to be hosting during the month of October. But for our purposes today, we're going to talk about who's eligible when we're considering who may be requesting and taking leave. It's a really good question because the Maine Paid Family Medical Leave Act is a clear departure from both federal FML and Maine state FML law. Maine's paid family medical leave law does not require a threshold period of employment with any particular employer. Instead, the threshold is going to be whether the employee has earned a threshold amount of wages from any combination of employers during the first 4 of the last 5 completed calendar quarters immediately preceding the first day of an individual's benefit year. What does that mean? It means that any of your employees who've earned at least $6,868 during the 15-month period preceding their request is going to be eligible. There is no threshold for how long the employee has worked for any singular employer, and instead it's whether the employee meets the wage threshold. And that, again, the wages can come from any number of employers. That 6,868 number is 6 times the state's average weekly wage rate for 2024. So this is very different from what you're used to with both state and family or state and federal FML, which require threshold periods of employment with one employer, or a number of hours worked with one employer. Not the way this works. Also distinctively different and not yet entirely clear is the fact that under Maine's Paid Family Medical Leave Act, the employee's job is not protected if the employee has not worked for the employer for at least 120 days. So this means you may have eligible employees because they've earned the threshold amount through different periods of employment with other employers. However, if they haven't worked for you for at least 120 days before they request and maybe are approved for leave, according to the statute as written right now and the proposed rules, those employees don't have job protection. So we are waiting for additional clarification again from the Maine Department of Labor, but as it's written, there is no requirement for you to hold those employees' jobs. They're simply entitled to the paid leave for the weeks or time period in which they're approved for the leave. And we can move to the next slide, which is going to talk about who is earning wages in Maine. Again, because in order to be eligible, the employee has to be earning wages in Maine. The Department of Labor has made it clear that wage calculations will be based on a larger segment of employees who are not traditionally subject to the Maine unemployment contributions tax. The Maine Department of Labor recently rolled out, in response to frequently asked questions, a list of 4 factors, one of which remains a little bit ambiguous, and we're hoping to obtain some additional clarification on factor number 3, which you see is the place from which service is directed or controlled. Based on that factor, an employer may have remote employees in Massachusetts, New Hampshire, Vermont, perhaps another paid family medical leave state. And if those remote employees are not reporting to any place of work and they are taking direction and control from a supervisor or direct report in Maine, those employees, based on just a clear read of this provision, look like they would be eligible to apply for leave. We're waiting for additional clarification on that. In terms of the types of leave that your employees may be requesting under MPFML, there are essentially 3 qualifying reasons for leave. And these are a little bit similar to what you're used to with state and federal, but also a little bit broader. Your employees may be applying for family leave, which is the traditional sort of leave that would cover caring for a new child within the first 12 months after birth, adoption, or foster care. It could be leave to care for a sick family member, but it also includes leave to take care for service members and leave to attend to a qualified exigency, which would mean if you have a family member who is called to active duty or is deployed and you need to attend to different needs associated with that family service member or the deployment, that would be another qualifying reason under family leave. Another reason, obviously, is medical leave, and that would be for the employee's own serious health condition. And then we have safe leave, which is leave to care for yourself or a family member who's been involved in violence, assault, sexual assault, or any other reason that would qualify the employee or the employee's family member for a protective order. So this would encompass time in court seeking a protective order. It could be obtaining medical care or mental health counseling related to the protective order. It could be making the home secure from the perpetrator. And there are a variety of reasons listed in the statute and the proposed rules that are covered as safe leave. Additionally, similar to state and federal FMLA, employees can request continuous leave, which would be a chunk of time related to a medical procedure and the recovery therefrom. They may be requesting intermittent leave, which is need that might happen on an as-needed basis if there's a flare-up or an unpredictable need for medical appointments. And then there is also the reduced hours leave. So those three types of leave are very similar. So yet another departure from both federal and state family medical leave. Maine's paid family medical leave is going to allow employees to request and take leave to care for individuals who are not biological or legal family members, but individuals with whom the employee has a significant bond that is like a family relationship. Initially, the MDOL referred to this as an affinity relationship, and they moved away from that definition to significant personal bond. And they've done this in order to emphasize that employees should be entitled to take leave when that leave is to care for anyone with whom they share a strong family-like connection without requiring a legal or biological relationship. The proposed rules list a number of factors that you see here on the slide. All of these factors are to be considered by the leave administrator when determining whether or not the employee has established the existence of a significant bond or a strong family-like relationship. None of these factors alone are determinative, and it's a matter of the administrator looking at the entire set of circumstances to determine whether the employee has established that. So again, this is a significant departure from what you're accustomed to under federal and state medical leave processes, and it's also a significantly different from most other state paid family medical leave programs. Moving on to slide number 15. Finally, we are going to talk about what is the employee required to report or request from their employer when the employee is attempting to utilize Maine's paid family medical leave. Again, also very different from what you're used to. In terms of Maine's paid family medical leave, employers cannot require their employees to use a standard form to request the leave from the employer. So employers may provide a form, and they may provide sort of a questionnaire and a predetermined set of issues for the employee to address, but the employer cannot require the employee to use that form in order to request paid family or medical leave. Now, while you can't require the employee to use a certain form, you are entitled as employers to require written notice and up to 30 days written notice of the employee's notice that they are requesting or plan to request paid family medical leave. Very different. Again, this written notice can take any form. It can be very informal. It can come in the form of an email or a text message. It may come from a family member. It might even come from a coworker. So employers are going to have to work hard to, train their supervisors and HR departments to recognize that these requests for Maine paid family medical leave may be made in very informal writings from employees. So while the notice may be informal, there are 3 things at least that the employee is required to provide in the request to the employer. The employee is going to need to provide the reason why the employee is requesting leave, whether it's family, medical, safe leave, leave for a qualified exigency. The employee is also going to be required to provide the type of leave that they're seeking, whether that is continuous. Is the employee seeking to take all 12 weeks at one time, all 6 weeks? Or is this a need for intermittent leave where the employee is only seeking leave to attend to, doctor's appointments and checkups and flare-ups as the need might arise? Or is it a reduced schedule leave where the employee is asking to work half days or, 3/4 days in order to care for someone with whom they have a strong family relationship? So those 3 things must be provided in the notice to the employer. We're going to move along to slide number 16 to talk about undue hardship. Again, this will also be an adjustment for employers. In the way Maine's paid family medical leave law works, an employer who seeks to establish that the timing or the duration of the requested leave constitutes an undue hardship is required to notify the employee of the reason why it is a hardship in writing at the time of the request. So if you're an employer, an employee comes to you with a request to utilize Maine's paid family medical leave, if the employer believes that it wants to assert an undue hardship defense to the timing of the leave or the timing of the month or the week or whenever the employee wants to take the leave, the employer is going to have to provide the employee with an explanation in writing of why it is that the timing or the duration of leave is going to significantly impact the operation of the business or cause a significant expense. So under the current proposed rules, if an employer does not notify the employee of the undue hardship in writing at the time of the request, the employer cannot later claim this as a defense. And then much like the ADA's interactive process, the Maine paid family medical leave guidance requires employers to then interact with the requesting employee to try and agree upon a reasonable time. So if the employee or the family member or neighbor or whomever the employee is seeking to care for has some wiggle room as to when appointments are scheduled or when a procedure takes place, the employee and the employer are expected to discuss that and work together to determine the most appropriate and convenient time that suits the needs of the employer and the employee. When the request is for a medical procedure or anything related to medical care, if the healthcare provider provides a response that says, there is no wiggle room, this is critical, it has to happen on X date at X time, and she's going to require 3 weeks to recover, this is always going to trump the employer's claim of undue hardship. So to the extent that the medical provider states that there's no wiggle room and it has to happen at the time that it was requested to happen, this is something that will have to get appealed through the administrator, which we will talk about in a little bit. So moving on to slide number 17, this is what we just talked about, applying for leave with the administrator. So first we have the situation where the employee has to request leave from the employer, and the employer again can require 30 days of written notice, except in instances where the need for leave is on an emergency basis or is not foreseeable. But aside from requesting the leave from the employer, the employee is going to need to request leave from the PFML administrator. So we don't know yet what Maine's portal will look like, but we know the Maine Department of Labor and PFML administrator has coordinated with, an IT provider, and there will be a portal. So employees will need to go into the portal, in order to apply for leave. It is very important to remember that employees are still required to comply with all of the employer's regular rules related to requesting time off and, requesting late arrivals or anything related to schedule changes. So the employee still is required to comply with the employer's rules related to that. But on top of that, the employee is then going to apply for leave with the administrator, and the timing of this is a little different and may cause some problems for employers down the road from what we understand. So the employee has to request leave no more than 60 days before the start date of the anticipated leave, and no more than 90 days after the start date of the anticipated leave. The issue here is that we may have employees who stop showing up for work, report to their employer that they're planning to request Maine paid family medical leave, and then delay in following the administrative procedures and going through the portal to request the leave. And that's an instance where we would encourage employers to contact their attorney to understand how to deal with that leave during that period. So the employee is going to be required to submit their leave process through the portal. And then once that leave request is submitted through the portal, the leave administrator is required to notify you, the employer, of receiving the employee's application within 5 days of receiving the application. So again, your employee is supposed to, in a perfect world, notify you, the employer, first. That may or may not happen. You're allowed to follow your rules. But again, I encourage you to contact counsel. Then the employee may go through the portal to request the leave, and you will find out from the leave administrator that your employee has requested leave. Moving on to slide 18, this discusses the process once the request is made. To the extent that the employee and the employer have agreed upon the timing of leave, again, this is in the perfect world where the employee provides advance notice. The employer says, yes, okay, these dates will work, we'll get coverage. If there is agreement and the employee provides the application, then the application is supposed to be immediately processed for review by the leave administrator. We can't tell you exactly what this means. We hope to have some additional clarification from the PFMLA authority about what does immediately processed mean. But to the extent that there is agreement, it should be immediately processed. If there is disagreement about the dates of leave and whether or not the employee has proposed something that the employer claims is an undue hardship, then the employer has 10 days after receiving notice of the request to provide the administrator with evidence of why the timing of the request is the undue hardship. So that's when the employer is going to submit into the portal the same written notice that they provided to the employee, plus any additional evidence that you may have to establish that the employee's planned leave is an undue hardship to you. Following the administrator's decision as to undue hardship and which party prevailed, either aggrieved party has then 15 days to appeal that decision. We don't know how long it's going to take the administrator to make a decision regarding these things. We understand from other state paid family medical leave programs that some of these decisions take months. So we will just have to wait and see how it goes in the state of Maine. But we do know that the employee's application is not processed until the appeal is resolved. So this could be a lengthy process. And then moving on again to the application for leave with the administrator. What the administrator is required to do once it grants the employee's request is it has to provide certain information to the employers. So once the administrator approves a request for paid family medical leave, that administrator will communicate to the employer the benefit amount that the employee has been approved for, the time period of leave, the reason for leave, and the date of benefit payments. Again, employers utilizing PFML have to follow all of the employer's standard reporting procedures. So to the extent that you have an employee who is approved for intermittent leave and it's on an as-needed basis, that employee is still required to follow your rules regarding, calling out, letting the employer know that they're going to be utilizing part of their intermittent leave and making sure they're following all the same policies. The employee who gets approved for intermittent leave does not have to go back to the administrator each time they take their intermittent leave, but they do need to let the employee know when they're going to be out. And with that, I will pass this along to Shelley.
Great. Thank you, Amy. So let's talk about what you should be doing to prepare. So let's start with planning for 2025. And 2025 is really all about planning for the contributions to begin, because again, as we've discussed, that pretty much every employer in the state of Maine is going to have to start contributing as of 1/1/2025. So the first decision you'll want to focus on is to what extent do you want to help contribute towards the 50% allowable cost to the employees. So again, as Leora had pointed out earlier, if you're a small employer with less than 15 employees, you do not have to contribute towards the program, and you can charge the employees the 0.5% or half of the 1% premium cost. If you're a large employer, again, as Leora had pointed out, you are mandated to pay at least 50% of the premium or 0.5% of payroll, but you have the choice of charging up to 50% to the employees. And then beyond that, you can make a decision and say, well, we're going to pay either as a small employer or a large employer. Maybe you'll decide to pay all the costs for every employee. If you do that, you need to do that across all classes and all employees. So you can't discriminate as a proportion of their costs. So if you decide to cover the 50%, you need to cover 50% for all classes, with the exception of the collective bargaining agreements. And this applies to private and public employers in this case. So if that's a negotiated benefit, then you can differentiate how much you're going to cover towards the employee's cost as part of that agreement. So then beyond that, what about short-term disability plans that are in existence? Again, as a reminder, 2025 is about premiums beginning. Benefits don't begin until May of 2026. So employers will want to continue to keep their short-term disability plans in place, at least up until May 2026. And so with that, in terms of budgeting, because again, potentially an additional cost to employees and or employers for the new benefit, the PFML benefit. So maybe you want to make some adjustments to your contribution structure for your short-term disability plans. If you have a voluntary plan for, let's say, as a small employer, maybe you do want to do some cost sharing of that to help alleviate the cost to the employees for the PFML, or vice versa. If you're a large employer with an employer paid plan with that additional cost of the PFML benefit, maybe you do want to do some more cost sharing on the existing short-term disability plan. Again, just something to consider, but we don't anticipate a lot of brokers making that change, but we do want to point that out, that that is something that you will want to review before the 1/1/2025. Okay. And on to payroll. Thank you. So the payroll deductions, again, that will begin as well January 1, 2025. And so with that, you'll want to reach out to your payroll company to make sure they're ready to go, and you've told them how much is going to be deducted from employees' paychecks. We do anticipate the Department of Labor informing payroll companies about the program, so we do expect them to be knowledgeable in terms of what's coming for them. But again, a good idea to reach out and make sure you have confirmation of that they're ready to go. And then as part of the program as well, there's going to be a remittance of the premium as well as contribution reporting, again, beginning first quarter 2025. All employers will need to register, and there's a portal going to be in the process of being set up that will accept all the premium contributions as well as the reporting. And so again, you're going to want to make sure your payroll company will be taking on that responsibility. And that's going to be a quarterly filing. So you'll remit each calendar quarter the any withholdings as well as the employer contribution, as well as the contribution report, and that will be due the following month after the close of the calendar quarter. So for example, the first quarter of 2025, you will need to remit premiums as well as the contribution report by the end of April. And that is something that will continue each quarter. And it's very similar to the schedule for filing your 941. There is a penalty for failure to remit premiums, and that is a 1% of your quarterly payroll. So for each quarter that you fail to remit premiums or submit a contribution report, you can incur a 1% penalty, again, of that quarterly payroll, I'm sorry. And then if you do fail to remit that quarterly premium, then you are then subject to the liability of having to fully pay any incurred leave benefits payable to your employees. Okay, another big piece of and this is a big topic, clearly, a lot to go through here. So another key piece of planning for 2025, which is definitely requiring a lot of attention. There's a lot of changes here with the revised rules. The initial set of rules that came out did not allow for private plan substitutions until April of 2026. The revised rules, based on a lot of employer feedback back to the Department of Labor, made an adjustment, and they are now making private plan substitution, again, based on the latest rules, available to employers effective April 1st, 2025. So that's a full year earlier than initially released. So that's a benefit. And so that's going to be a process where you will submit an application, again, beginning April 1, to the DOL. It'll be submitted online. It's going to be the same portal you'll be using to submit premiums as well as, again, the contribution reporting. And that will be accepted by the DOL on a rolling basis. So there's not going to be kind of a hard deadline of submitting that, other than when your exemption will go into play, which we'll talk about. For a fully insured plan, this employer must submit a contract with a carrier showing proof of that contract, and that will be submitted for approval by the DOL. And then for a self-insured plan, the employer will need to post a bond along with submitting all the plan parameters to make sure they meet the requirements of being substantially equivalent. So there will be an application fee that applies to these applications, and as of the cost as of April 1, subject to change each year. But for now, the cost will be $250 for review of the application, and an additional $250 once the application is approved. So these applications will be processed on a quarterly basis. So this is somewhat complicated. So let's walk through this. So what that means, again, beginning April 1st, 2025, if you submit an application in the first 2 months of that calendar quarter, and the Department of Labor approves that application prior to the end of that same quarter, then the exemption from paying into the public option stops as of beginning the first day of that quarter. So in other words, so let's say you apply April 3rd, 2025 to substitute a private plan. The DOL approves that in June of 2025. Then you will no longer have to pay into the public plan as of April 1st, 2025. And that applies for every subsequent calendar quarter. So it's a kind of a rolling quarter in terms of getting approval to substitute the private plan for the public plan option. Now, in the meantime, for that particular quarter, if you have been doing payroll deductions for your employees' portion of the premium, upon approval of that private plan substitution, you will then have to refund any premiums that were withheld for the employee back to the beginning of that quarter, the effective date of the exemption, within 30 days of the withholding. Okay. So, so again, as an example, your approval is received in June, and you've been withholding premiums through April 1st to, let's say, June 15th, you will have to refund any premiums withheld from your employees from April 1st to June 15th, within 30 days of June 15th. If you apply for an exemption the last month of any calendar quarter, that application will not be approved until no earlier than the first of the subsequent quarter. So again, if you submit an application, let's say June 2025, the earliest your exemption can be available to you for private plan substitution would be July 1st, 2025. So it's pretty much a rolling quarter each quarter of when you can apply. Once you make the decision to go with a private plan, you must stay with the private plan option for at least 3 years. If you do have a good cause reason to cancel it, you could get approval from the Department of Labor. We do not have details yet of what that means. There's been mention of a premium increase could be a reason, a good cause reason, but we don't know to what extent, if there's going to be parameters around the level of the premium increase that would allow for a cancellation of a private plan. Next slide. So what does this mean in terms of making a decision of whether this is going to be a preferable option for you? So you're going to want to work with a broker and take a look at your options. As there's several carriers out there currently that are providing quotes, illustrative quotes for putting a private plan substitution in place. Obviously, a big driving factor is going to be premium cost. So if a private plan could be less expensive than the public option, it could be less than 1% of payroll. But let's say you decide maybe it still makes sense to you to go with a private plan that maybe is a little bit more expensive than the public option. If you do make that decision, you cannot charge the employees their portion more than what it would have cost if they were with the public plan. So in other words, you cannot charge them more than 0.5% of payroll if you choose to go with a private plan, regardless of the cost. Potentially, again, another example of a reason potentially to look at a private plan substitution. If you get your application in and it is approved in the second quarter of 2025, then effectively you could avoid paying into the public plan for up to 13 months. Because at that point, your premium for a private plan would not begin until May of 2026. So if you are granted an exemption that's in effect as of April 1, 2025, potentially could save 13 months of premiums. Another reason to potentially think of a private plan substitution, it could allow for smoother integration with existing short-term disability plan, especially if you continue it after April 2026, which we'll talk about, as well as long-term disability coverage where employees can have a much smoother transition into a long-term disability plan, or if they have a short-term disability plan that's going to augment the PFML weekly benefit, it could be a much more easy transition if it's consolidated with the same carrier. And then lastly, brokers can facilitate resolution of claim issues with private plans, so they can help with any issues with a private carrier. That's something that we're not anticipating will be available when working with a public plan option. So Amy just talked about the outreach campaign that the Department of Labor is just in the process of announcing. In addition to that, obviously making your employees aware of those webinars, but you're also going to want to reach out and let them know about the upcoming payroll deductions should you decide to pass on 50% of the cost to the employees. And so you're going to want to make sure they're aware of that. That's going to be an upcoming cost to them beginning January 1, 2025. The Department of Labor will be providing a workplace notice, and we also will have a requirement to notify your employees about the program within 30 days of their date of hire. Again, both of those notices and a template for the notice, we are anticipating to be released by the Department of Labor before the end of the year. But we have not received anything definitive at this point on the timing of those notices. Okay. All right, now we're going to move into 2026. So again, we just talked about premium contributions. 2025 is about planning for paying into either the public option or applying for a private plan exemption. Planning for 2026 is all about planning for the payment of benefits. Because as we discussed, the benefits are not payable until May 2026. And so for that, you're going to want to think about what does this mean for your existing disability plans, whether it's short-term disability or long-term disability. So for short-term disability, and for the most part, we're talking about group insurance. We're not really talking at this point for maybe individual contracts through, let's say, like AFLAC. Which may not be affected by these plans. But for a group disability plan, are you going to make any adjustments? as brokers and advisors, we're not recommending that employers drop their short-term disability plans, but obviously it's something that each employer is going to want to weigh for them based on their own circumstances. The reasons to continue a short-term disability plan be one, because PFML benefits clearly can be used for family leave as well. So obviously a high utilization potentially, especially maternity and bonding time. So a employee could end up using all their PFML benefits for bonding with a child, and then they have nothing available to them should they have their own medical issue arise. And if there's an existing short-term disability plan, potentially that plan would then be able to step in and pay for an employee's own medical leave and cover that benefit. In addition to again, keeping it for other medical leave reasons, for higher income employees, the PFML benefit may not be sufficient in terms of income replacement. The disability benefit, the PFML benefit is a progressive benefit, but it is capped at $11.44 per week, as we previously pointed out. And so for higher income employees, that's not going to replace a substantial amount of income. And so the short-term disability plan can be used to augment that weekly benefit. So we do know that from conversation with the carriers, there's an anticipation that those premiums, if you keep it beyond the April 2026, will drop substantially because the short-term disability plans will be offset by the PFML benefit. So employees will not be able to double dip between a short-term disability plan offered on a group basis as well as the PFML benefit. But you will be able to use those short-term disability benefits to augment and pay a higher weekly amount than just what's available through the PFML plan. Other considerations, you want to change your contribution structure. So maybe you are paying, again, 100% of a short-term disability plan for your employees. And now with the additional cost of the PFML benefit, maybe you want to change that to a voluntary structure. Or conversely, you're paying for all your employees, and maybe you do want to help the higher income be able to have higher income replacement benefits, and so you will continue to pay short-term disability coverage for those employees. But again, the cost of those benefits would come down substantially from what you're paying currently because of the PFML offset. Other consideration, and this is more around simplicity and ability to clearly communicate, and that is, do you want to adjust your maximum benefit period? So short-term disability plans quite often are written on a max benefit of 12 or 13 weeks or potentially 26 weeks. And since the PFML maximum benefit time is 12 weeks, maybe you want to adjust a 26-week short-term disability plan down to 12 weeks just to make it easier to communicate in terms of how it works with your short-term, with your PFML benefit. And then same thing with your long-term disability plan. Again, maybe you have a elimination period of 180 days on your LTD plan, and maybe you want to make an adjustment again just to make it easier to understand how the two plans work together, and make that a 90-day elimination period. And so those are just, again, just some considerations. You do have time on that because, again, benefits are not payable until May of 2026. And now I'm going to hand it back to Amy.
So additional considerations for employers to make, setting aside the financial aspects of it and the benefit payment aspects, we're going to talk a little bit about what you want to look at from a policy and procedure and human resources perspective. Employers are going to want to look at their policies right now and determine whether or not they are going to make any revisions to their policies. While we have proposed that employers should include a description of Maine paid family medical leave, I think this is something that we might want to hold off on just a little bit because, as we talked about earlier in the webinar, we are now awaiting for the Maine Department of Labor to roll out the final regulations. So as you may recall, there was an initial comment series following the first set of proposed regulations. Then we've just finished the second comments series, which closed yesterday. So at this point, the PFML administrator and Department of Labor are considering the comments that were provided up through and including yesterday. And we anticipate additional revise or additionally revise proposed rules and regulations to roll out prior to January 1st, 2025. So once we have those additionally revised rules, we'll want to take a hard look at them and make sure that employers are including a description of the MPFML requirements and processes in your guidance to employees. You want to make sure that your handbook, if it addresses sick leave, PTO, Maine family medical leave, federal family medical leave, and any other leave entitlements, you want to make sure that your handbook conveys, to the extent that this is your plan, that MPFML runs concurrently with any of these other types of leave. It is stated explicitly in the statute that employers may run MPFML concurrently with sick leave, PTO, your Maine state family medical leave, and federal FML, and any other leave entitlements that employees are entitled to. So, we've discussed that there is a 12-week maximum. I've discussed that the leave can be taken for family, medical, safe leave purposes. That 12 weeks is 12 weeks in the aggregate. So you can't take 12 weeks of family leave and then 12 weeks to deal with a qualified exigency related to a covered service member who's in your family. It's a total of 12 weeks, and those weeks need to run concurrently with other time off benefits that the employees have. Shelley spoke to the fact that you may be wanting to augment the Maine paid family medical leave payments with short-term disability funds. It's also an option for employers to consider what their PTO benefits look like and whether they will allow employees to top off or augment their Maine paid family medical leave payments with PTO benefits that they may have through the company. So these are all considerations that employers should begin engaging with now. Employers should be deciding whether they want to modify or use a current form for employees to make requests. Though again, employers cannot require employees to use the form, but to the extent that you want to provide one and make sure employees understand that this is one means of requesting Maine paid family medical leave, you can consider whether to do that. Again, the con associated with that situation is you don't want to be faced down the line with an employee who claims that, he didn't know there was a form and he sent an email and somehow the employee's supervisor or manager didn't recognize the email as a request for PFML. So we need to be very careful with forms because the statute explicitly does not allow you to require the use of one. Again, Shelley described all sorts of benefit options. This is another situation where employers may want to work with a third-party administrator on compliance. It is critical for employers to remember that when you're working with a third-party administrator, it is the employer's obligation to comply with the law. So we are seeing in many instances in other states with new paid family medical leave processes that sometimes third-party administrators get it wrong. Sometimes they're trying to determine something that really hasn't been determined yet, even by the state PFML fund, because it's new and just developing. If there is liability associated with a misstep, it is ultimately the employer's responsibility. So you want to make sure that you're carefully talking with a third-party benefit administrator regarding compliance. The employer wants to make sure that they are owning the decisions and have visibility into the decisions, and they're working together with the TPA, and that this is not a set it and forget it sort of arrangement. It's also critical for employers to think about training their managers and supervisors on recognizing requests, just as you've been training your managers and frontline supervisors to recognize requests for accommodations under the Pregnant Workers Fairness Act. This is another step towards recognizing informal requests. It can be a text message. And again, this is going to be adjustment for all of the employers who are operating with Maine paid family medical leave impacting their workforces. So starting with training now and making sure you understand what to look out for is critical. And then lastly, this is just a really logistical issue. According to the statute, you don't have to allow your employees to take leave in less than 8-hour increments, but you do have the option to allow leave in less than 8-hour increments. So you need to think about how that impacts your, how it impacts PTO and other benefits that may be available. Do you want to require employees to take a full 8 hours if they have appointments that maybe last only 1 hour or 2 hours? Again, this is a strategy call that employers should be talking with their outside counsel about, talk with your inside counsel about it, and make sure you understand the pros and cons associated with the increments of time that you're allowing the employees to take the Maine paid family medical leave. Essentially, the recommendation really is that it should be match up with what you're already providing in terms of increments of federal FML and state FML in order to avoid additional confusion with running these concurrently. And it looks like we're almost at the top of the hour. And so I will pass it back off to Leora and thank everybody for participating today.
Thanks everyone for joining us today. I know we're about 3 minutes of the hour. We really appreciate you taking the time out of your busy day to join us today. We have about 3 minutes left, so if you do have a question, you can type it into the chat. We're not going to have time to answer very specific questions, but if we have something general that you want to ask about that we didn't touch on, please do enter it into the chat. Otherwise, if you have specific questions, of course, reach out to your attorney, to your benefit brokers, to your HR contacts. This, again, like we said, is going to be a developing issue, and so we're going to keep updating you and keep track of it as it goes along. I don't see any questions. We'll stay on for another 3 minutes, but if you can jump off if you want. Thank you again. Hope you all have a good day.
Thank you all.
Thank you. Good luck and may the force be with you. Call us.
All right. Kristen, I think you can end the. Thank you very much. Thank you, Shelley. Thank you, Amy.
Thank you.
Thank you all.